Okay. Hello, everybody. I'd like to welcome you to this special meeting of the Sonoma Valley Citizen Advisory Commission. I believe we will start by a call to order. This is as of March 9th, 2022, and I think we'll start with a roll call by our esteemed Secretary, Ms. Spalding.
Did you want to do the pledge first, Chair
Okay,
Freeman?
that's great.
Or doesn't matter to me, but okay.
You'll follow along. I pledge allegiance
to the
flag of the United States of America and to the republic for which it stands, one nation, indivisible, with liberty and justice for all. Thank you very much. And now roll call.
Indeed, thank you. And Chair Freeman,
Here.
Secretary Spalding is here. Vice Chair Dickey,
Here.
Commissioner Mullen.
Here.
Mullen, there you are. And Commissioner Kokonen.
Here.
And Commissioner has apparently resigned from the commission. Thank her. Commissioner Brown.
Here.
Commissioner Truesdale.
Here.
Commissioner Polverenti.
Here.
And Commissioner Vella. Commissioner Vella, I see you. Good. Commissioner Lowe is excused. Do we have Commissioner ex officio Felder? And then we move to Commissioner Cornwall. Carr, sometimes known as Guru Greg.
Here.
All right, and ex officio, excuse me, Commissioner Branford, Emeritus. Did I leave anybody out?
No, I believe you've captured everybody.
Thank you.
Thank you. Now we'll move to item number 2 on tonight's agenda, which is public comment. And this is limited to items not appearing on the agenda. Again, this is a special meeting where we are receiving a overview and process discussion about the environmental impact report process. However, if anybody has anything that they'd like to mention, please raise your hand. And for attendees who, let me see here. Well, raise your hand and we'll call on you.
I'm not seeing any raised hands.
I would agree. And since we only have four attendees outside, I think we are good to call that public comment session closed. And now to move to our environmental impact report overview and process. I'd just like to mention a few things first, that this is a special meeting on a topic of great community interest. We will, in this meeting, we are going to enable the chat feature in Zoom during this presentation. I want to note that that chat should be limited to shorter questions. There will be time to ask questions during public comment. However, we ask that you keep those questions short and to the point. If they get too long or too numerous, we won't be able to answer them tonight, but they will be entered into the record. Let's see, there was one other thing I wanted to point out. The chat record transcript will become a part of the public materials from the meeting and will be included as an attachment to the minutes when they are compiled. I would encourage anybody, as with spoken comments, who makes any comments in chat to refrain from personal attacks, just as you would if you were speaking. Thank you very much. And when we do have public comment or Q&A time, please I want to remind people to raise their hand. And call-in users can press *9 to raise their hand and *6 to unmute. With that, I would like to introduce Mr. Brian O. with the Planning Department and Mr. Ex Officio Greg Carr, who are going to give us our presentation tonight. I hand it over to these able-bodied gentlemen.
Thanks, Mr. Chairman. So Brian and I have put together an outline for you, and it's just a one-page outline that we'll screen share when we get going. A couple other just points to make to add to what you mentioned, Mr. Chairman. We are going to break the presentation up at least once and maybe more often if necessary for questions. So we're not planning on going through all the way through the presentation. SQL is pretty complicated, and questions may arise as we go along. So through the chat and through those question periods, we're hoping we can answer. And when I'm presenting in the early part, if there are chat questions that come up that Brian can answer quickly, he'll do that. And he is going to do part of the presentation later on. And when that's going on, I'll try to answer any chat questions that come up. If we don't answer your question, it's not because we don't want to, it's just because it's not something that lends itself to a quick answer on the chat format. And we'll try to capture all those chat questions during the question and answer period and see if we can't provide a little more information if necessary. I do think that it's important to mention, and judging so far by the number of attendees, maybe people have already got this figured out. This is not a discussion or comment period for any of the projects that are going on in the Valley, whether it be SDC or Springs Plan or housing sites or cannabis dispensaries or anything else. This is really just an informative, we hope informative session on what's involved in an EIR. And obviously knowing a little bit about EIRs helps you get involved in those various projects that are going along, but this is not either informally or formally any kind of attempt to gather comments in an official way on any project. And hopefully that'll help everybody get through this. The other thing I want to mention, though, to the extent that as we go through this question, you may have questions that pertain to one of those two projects with respect to the EIR process. That's fine. That's fair game, and we'll try to provide it. In fact, Brian's presentation will go into the specific processes that are involved in the EIRs and give you a good idea of where and how to get involved in those pieces of the EIR. So I'm going to just go ahead and start out. If there are any questions initially from commissioners before I get going on this? Okay. So you guys have said over a couple of the last meetings a couple things. One is that you're not only interested in finding out what's going on with EIRs, but you also have some general concerns about the kinds of projects that are going through in the Valley, and who's minding the store, who's keeping track of what's going on in a more cumulative way. And I completely understand that. And because I'm sort of stuck at this point, it looks like with sitting on the Planning Commission for the SDC, for the Springs Plan, and for the housing sites proposal, I'm sort of feeling the same way. So, man, this is a lot of stuff. So anyway, I want to point out that I think that it's relatively unusual in Sonoma County to have that situation, but it's definitely going on now. And I do think that it's important for you guys to have some of this background to the extent you might be able to use it. A little bit of background on SQL. And by the way, SQL, beware of acronyms in this presentation. If we ever give you an acronym, you don't know what it is, please raise your hand or holler or something. Environmental review under the California Environmental Quality Act is extremely complicated. And fairly lengthy depending on the project and impacts. And there have been countless court cases over the 50 years since this act was first passed by the legislature, many law changes affecting different parts of the process. And, you know, Brian and I could probably spend about 3 or 4 full days going through the entire SQL process and trying to get you oriented. If you were going to be a practitioner, member of the Board of Supervisors to some extent, planning commissioners, need a little more background. We're just going to really focus mostly on just an EIR portion of the process. And we are going to cover a few of the steps that lead to a decision to make an EIR, because those are oftentimes as important as the EIR itself. So I want to read a couple things, and these are out of the legislation and out of the Sql Guidelines, which I'll explain a little bit later. But I just think these couple of things I want to read are quotes from the law, and I think they are very important to understand, because in the end, a lot of times court cases end up going, well, what is the heck the purpose of this thing anyway? So this is a quote from the Public Resources Code. This is from the legislative mandate. Public agencies should not approve projects as proposed if there are feasible alternatives or feasible mitigation measures available, which would substantially lessen the significant environmental effects of such projects. If specific economic, social, or other conditions render infeasible the alternatives or the mitigation measures, then the project can be approved with those effects. Now, there's a lot of buzzwords in that legislative mandate, which we'll try to get into a little bit later. Feasible, alternative, significant. All these are judgment calls under the California Environmental Quality Act. So when you get to a point where you're going to do an EIR on a project, you need to really focus on several purposes. The first purpose of an EIR is to inform the public and the decision makers about the impacts of the project. And that's critical because, as we'll talk later about public input and what it means and what the EIR means to the decision maker. It's to identify the impacts. It's to identify whether those impacts are significant or not. It's to identify alternatives to the project that is proposed. It's to identify additional mitigation measures to the project as proposed that were not considered when the decision was made to do an EIR. So in reality, what the challenge, the general challenge for any kind of an EIR process is to identify the impacts, and if they're significant, try to avoid them. And there are many ways to do that through mitigation and through changes in the project. So the second sort of document that I want to identify for you are the Sql Guidelines. And I'm going to give you the references to these later on. We'll give you the websites, and if you want to dig further into this, you can. But the California Office of Planning and Research maintains guidelines on EIRs, guidelines on Sql entirely, but also on EIRs, and provides a lot of background and definitions and discussion around what some of these terms like feasible and a range of alternatives, what all that really means. But section 15002 of the guidelines, and you can follow after that section, talks about how you inform the public, how you inform decision makers, how you prevent significant effects on the environment. And if you have to accept a project that has significant effects, why are you allowing them? So first of all, Sql is limited to discretionary projects. And you may have heard me over the years try to distinguish between ministerial projects and discretionary projects. Basically, the difference is ministerial projects are the decision maker exercises no judgment. Be like a building permit. The building permit, the permit has to comply with the building code, and that's it. If you do, you get it approved. If you don't get it approved. Discretionary project requires judgment. So such projects as new wineries or subdivisions, or the type of project where a discretionary decision is going to be made by a decision-making body that has discretion over it, it has judgment. And these are where the standards are not necessarily 1 + 1 is 2. They require judgment. When we talked about the winery guidelines a few months ago, wineries require discretionary approval. And remember, we had a few standards that we were developing, and these standards were to be applied by the CAC when you looked at a winery project. But if you remember, some of those standards were very, very general and required judgment. So those are cases where SVCAC does apply, because there is discretion by the Board of Supervisors or Commission or whoever is making a decision. So when a EIR is being prepared, the duty of the impact analysis is to decide what impacts are significant and what impacts are not significant. And so I'm going to talk a little bit more about this part of the process in a little bit, but for now, a significant adverse change in the physical conditions of the area affected is a significant impact. Physical change in the area affected. So now I want one more quote, if it's okay. I kind of like some of these quotes. 15003 of the guidelines, I think, is a very important principle. SVCAC is intended to be interpreted in such a manner as to afford the fullest possible protection to the environment within the reasonable scope of the statutory language. So there's a really clear statement with that word in there, reasonable. And you'll find, no matter how many court cases you look at or how many different laws are made, and words like feasible and reasonable are very, very judgmental. And the challenge in an EIR is if you want to find something feasible or infeasible or reasonable or unreasonable, is to explain why. That it's critically important that the public understand why you're doing it, and it's critically important that decision makers understand why they're doing it, and that they give the reasons and they put the reasons in the record. So that's my pitch from the legislation and the guidelines themselves. And I'd strongly encourage you, if you want to get more in depth on some of the guidelines, they're very readable, very useful. They're the Bible for most planners that sit at their desk and try to figure out how to do this process and get it right. So each county and city is responsible for developing procedures for how they're going to carry out environmental review. And I don't know of any cities or counties that don't have these. You're required to have them. They may vary among jurisdictions, but basically, how are we going to go through all the steps of initial study, negative declarations, EIRs, public input, and what are the kinds of processes that we want to establish? The county has had procedures since the 70s. They've been amended a few times over the years, and they're available to you if you're interested in actually looking at them. Those procedures involve how and when are we going to conduct studies on a project? What kind of studies are we going to need to use? Traffic, air quality, etc. How we're going to prepare EIRs, how we're going to do consultation with, whether it be with tribes or neighborhoods or whatever technical agencies might be involved. And the procedures must have clear opportunities for public involvement and public review. So we've had, and the county's had these things for many years, and I'm sure Brian would help you with any further information you might need on that part of it. So the public input, just a word on that. There are probably 5 or 6 sections of the Sql guidelines that make clear the necessity of public input. It's not just the decision makers having the rationale. It's the public understands the rationale and agrees with it. Now, of course, public doesn't always agree with it, and sometimes lawsuits result from disagreements. But the purpose is to have a clear understanding of what the reasoning is in ways that protect the environment. So I'm going to kind of go to step 3 here on your outline. Oh, by the way, Brian, were you going to put the outline up, or I forgot to mention that?
Sure, I'm happy to do so. I know that Ariel had circulated. Would the commission like me to have it up? I know it might take away from the screen.
Okay, well, we can go on without it. It's just a 1-pager, but everybody's got a copy of that. You guys all got that? Okay, that's okay then. So let me cover the decision to prepare an EIR, and this is the last of the background stuff, and then we can get in maybe into more of the substance. So the first thing that the agency does is conduct an initial study. And there are checklists available. The county has a checklist. You can use the state checklist, which is provided. You often, if you're in the chair or vice chair of this commission, you often see what's called a referral, project referral that's going to come to you guys to decide whether you want to hear it, is the step just before an initial study is conducted. So all the comments that come in from the public and from different agencies through that referral process get sent to the planner or whoever the lead agency is for the project, and an initial study is conducted. And that study establishes a very important process. That's where a decision is made whether or not to prepare an EIR. And I would argue that that initial study and the effort to mitigate any apparent impacts and to decide whether to go down the road of a negative declaration versus going down the road of an EIR are critical to the future decisions made for that project. And I would also argue that that's probably the most contentious time during any kind of a discretionary project, because quite often it's not an easy judgment to make. You may have an impact that you're not quite sure about. You could be going back to the developer and saying, you know, can we do something about this? Is there a way we can maybe modify the project to reduce this potential impact? Some of those things are traffic, are good examples of an issue. Air quality, oftentimes emissions are triggered that would ask for an operator to, or a developer to do something a little bit different. But there probably have been more lawsuits over the effort that goes into deciding whether a negative declaration is appropriate or an EIR is appropriate at that, based on what happens in that particular stage. I guess well, I gave you a couple examples of studies. You know, you have a traffic issue on almost any development project has some level of traffic issue. So how do you decide whether or not the amount of traffic or the amount of congestion or the vehicle miles traveled is significant or not? And, you know, if you're just sitting there at your desk going, well, it doesn't feel very significant, it's really difficult. And a traffic impact, the same amount of traffic that's generated in a rural area may be completely different than the same amount of traffic generated in an urban area. So you have those kinds of dilemmas. So what do? Well, the most Sql professionals use thresholds of significance. And a good planning agency and environmental professional firm will have thresholds of significance that they use. County does this, cities do this. On traffic, the county's primary threshold of significance for determining an impact of traffic is the general plan LOS standard. So most county roadways, if they're operating at level of service C with a project, they're going to be eligible for a negative declaration. Not going to be considered significant. If they move a level of service from a C to a D, that's probably going to trigger either a much more involved study or a change in the project or going to an EIR. Those are the kinds of things you make. An air quality district may have a threshold of significance, and the county can often use the air quality district's threshold. So they may have like an emission standard for nitrogen oxide, maybe for greenhouse gas emissions. And typically, if the analysis of the project indicates that the emissions are above or below that particular threshold, that will either lead to some change in the project, perhaps some mitigation measure, or if nothing is available, going down the EIR path. So you can imagine the kinds of discussions and debate that occur within the departments, within the cities and counties at this stage in the process. Because developers, for very good reasons, don't want to do an EIR. You know, the expense of an EIR, they're going to have to pay for it. So the expense of an EIR is a huge economic burden for most developments. So a negative declaration is usually preferred. So there's often a willingness on the part of developers to go maybe reduce the number of rooms in a hotel, or reduce the number of, you know, the size of the event facility at a winery, you know, doing the kinds of things that might bring down whatever the impacts are causing. So this is where I want to talk a little bit about a couple things. Feasibility and reasonableness. Let's see, wait a minute, losing my place here. So when the agency says, we want you to reduce the hotel rooms, or they want you to reduce the emissions in some fashion or another, or we actually think this project is really ought to be moved over here. It's not really very feasible in this location in terms of its environmental impact. Well, oftentimes the reaction will be that the developer feels that mitigation is not feasible. And he or she may posture that based on its cost, based on whether or not it's legally attainable, based upon you know, the intensity of the particular use and the desire to meet certain goals that he or she has. So that oftentimes the determination of the significance depends on some definition of feasible. CEQA does not tell us what is feasible and what isn't. What it really tells us is you make a judgment on what's feasible and what's not. And you can consider any number of factors. You can consider location, and you consider scope, you can consider design, the extent, the intensity, any of those aspects of a project. What SQL wants is a good faith effort to define feasibility, and it wants you to explain why or why not a particular measure is not feasible. This is a very strong aspect of an EIR that I think always bears attention. Why is a particular mitigation measure feasible or not feasible? EIRs will often identify mitigation measures and then say this measure is not feasible for this reason, or this measure is feasible because it will reduce impacts. But the effort is always to find feasible ways to reduce impacts to a less than significant level. So the next thing I want to cover in an EIR is alternatives. And I think this probably is a word that's familiar to a lot of you over the last couple of months for various reasons. EIRs are required to analyze a range of feasible alternatives. And you will also see, SQL also wants the agency, in this case, the county, the lead agency, to identify a preferred alternative. Because the purpose of identifying a preferred alternative and a range of feasible alternatives is to enable a comparison of the merits of all those alternatives. So when you have a preferred alternative identified in an EIR, and you have a range of reasonable alternatives, you can decide which one is better. And in the end, the EIR is going to say which one is the environmentally superior alternative. And that will depend on, of course, on the analysis. So I want to quote this one section again from the guidelines, 15.126, if you're writing this stuff down. Alternatives shall describe a range of reasonable alternatives to the project, which would feasibly obtain most of the project objectives, but would avoid or substantially lessen any of the significant effects of the project and evaluate the comparative merits of the alternatives. And I kind of highlight, because of SDC, I kind of highlight that most of the project objectives. So again, it's a judgment call as you learn what the impacts of the preferred project are, and you learn what the impacts of the alternatives are. You can evaluate each of those alternatives based on the project objectives. And furthermore, you can disagree with the project objectives. I think that's a little difficult in most cases, but you don't have to agree with the objectives, and you can challenge that. You can say, you know, in your comments, you can say, you know, I don't think that objective is legitimate for whatever reason. That it's just really up to the decision-making body to accept what the objectives and to accept whether or not those objectives are met by each of the alternatives. But the EIR's job is to inform about that. So obviously in SDC, and I would argue ultimately in the Springs Plan and some of these other EIRs, that's a critical judgment about whether that EIR adequate to provide us with that kind of information. So the other thing that an EIR is required to do with respect to alternatives is to identify the impacts of the no project alternative. And this is not the same thing as just saying, well, if we don't have this project, nothing's going to happen. The challenge for CEQA is to speculate reasonably about what might happen on a property if the project is not approved. And so, you know, it depends, you know, if you're in the Springs or you're at a housing property and it's proposed in Glen Ellen, or you're in the SDC property, you know, what might happen there. So that's a job for the EIR, and usually doesn't result necessarily in the environmentally superior alternative. The environmentally superior alternative must at least meet some of the project objectives. So if you got no project, then it's pretty difficult to make the argument that you're meeting any of the project objectives. So I want to talk a little bit about, the alternatives analysis in an EIR. This is important, you'll find as you get into some of these EIRs, is that the analysis of the alternatives is not in the same depth of detail as the analysis of the preferred project. It's got to be enough to make a comparison, a legitimate comparison, but it doesn't have to be in as great a detail. If in the end, the decision makers don't like any of the alternatives, or they like one of the alternatives and not the preferred project, that's okay, as long as they have sound reasoning based on any objectives of, based on legal, economic, other reasons, but they need to explain why. And they need to provide that to the public for the folks to see, and they need to have it in front of them so that when they make that decision, it's a conscious decision to say, oh, this is okay, we're going to accept this because, and that's where feasibility and reasonableness come into play. Is that decision reasonable, given the facts, given the analysis that's taken place? So I just got a couple of things to cover, and then I'll just say we can do some questions. A few other important aspects of an EIR. An EIR must have a baseline condition from which to determine whether or not changes will be significant. So your baseline condition on a project might be a vacant property, yet vacant piece of land, and perhaps someone is proposing some type of development on that piece of land. So the baseline is pretty clear. If a project is redeveloping a property where maybe there's one use on the property now, and the project involves a change in the use, say from a single family residential subdivision to a resort or something, then the baseline is the use of that property. So you may have a situation where subdivision is generating X amount of traffic, and a new use is proposed that increases the traffic maybe by 10%. Well, the total amount of traffic from the new use may be a problem, but if it's only increasing the existing traffic by X, a smaller amount, it's the new use is not going to be burdened with the necessity of mitigating impacts that would have occurred under the old use. This is an interesting aspect of SDC, because SDC, there is no use of the SDC at the present time. However, there has been use of the SDC in the past. It's going to be interesting to see what the EIR for the SDC uses as a baseline. I'm not going to state an opinion, although I will eventually in my comments, but this is the kind of thing that comes up, and whatever is chosen there by this EIR will have to be explained and allow comment. Another aspect, and this goes right at what the CAC has been talking about with respect to cumulative impacts. An EIR is really the only time, other than maybe a general plan EIR or a general plan project, where you really get to look at the cumulative impacts of development in an area. And with respect to the 3 EIRs that are going through the process now, each of them are responsible for identifying other projects that can be reasonably foreseen, and there's reasonable again. But so you're looking around, you're trying to, okay, what's going on here? What's going on there? We're aware of this. Typically, the kind of projects that are looked upon as reasonably foreseeable are ones where there's been an application filed. It doesn't even have to be a complete application, but if someone has spent some money expressing an intent to develop, typically those are looped into the cumulative impact analysis. So obviously in Sonoma Valley, there's going to be a lot of analysis of cumulative impacts, depending on which one comes along first and second and third. A little bit on the types of EIRs. I heard this comment a lot when the scoping session was held for SDC, but why don't I see any site plans? Why don't I see any projects? And it's really important that the level of detail of an EIR is appropriate for the level of detail of the project. In this particular case, in all 3 of these, well, in 2 of the 3 cases, in the Springs and the SDC plans, the project is a plan. There is no development or construction directly related to the project. That will happen after the plan is adopted. So what you're looking for in an EIR for a plan, or the general plan, specific plan, any kind of larger action, is some speculation about the potential impacts that might arise from that plan. So for example, if you're looking at a market rate, 50 market rate units on a particular portion of a property in a plan, you may use a standard, traffic generation model to predict what might happen. That's going to come up. What you choose in that analysis will become important later on when projects come through. And we're going to spend a little time after Brian's presentation to kind of go through what happens after an EIR is approved for a plan and individual projects come through. So you have, in the case of the specific plans, you have what's called a program EIR. When you do a general plan update, you do a program EIR. When you do a specific project, building a commercial building down in 8th Street East, putting a winery in on ag land or whatever it is, that's a specific project that can be tied down very closely to the impacts that are going to be generated. And that's where a project EIR, if necessary, is the most appropriate level. But the bottom line is to remember that the level of detail of an EIR needs to match the level of detail of the particular project. And the last thing I want to talk about is worst case. Nothing in SQL, and Brian, please correct me if I'm wrong, nothing in SQL that says you got to look at the worst case in terms of impact. Do you need to be very conservative in terms of the significance of impact? Conservative, I mean leaning toward it's significant rather than it's not. And I will tell you that in my experience, leaning toward significance based on a worst case analysis is very much, puts you in a much better position as a lead agency with respect to legal challenges. Because if you argue that an impact is not significant and you haven't really looked at worst case of an impact within the scope of that particular project, you're open to challenges of adequacy. And I have to say that I've argued with this with environmental professionals over the years and with other planners and stuff like that. And it's not, there isn't agreement around that necessarily, but every time I've ever done it in my life, in my career, it's been, I have been so glad that I did at the end of the process, because, and especially when you're involved in a project that is sort of an easy call to do an EIR. All three of the projects that are going through EIR in Sonoma Valley right now are easy calls for doing an EIR. They're obviously involve quite a bit of development. They involve a lot of public controversy. If you try to do any of these with an egg deck, any of the project proponents and opponents would take you to a judge, and the judge would say, sorry, go do an EIR, and you'd lose a year. You may remember the cannabis ordinance that was proposed to the Board of Supervisors about a year and a half ago or so. The staff, under board direction, the staff tried to amend the cannabis ordinance with a negative declaration, arguing that by making the impacts and the project decision ministerial as opposed to discretionary, that would allow them to adopt the new ordinance much more quickly. It took about a year in hearings and several legal arguments made by opponents of cannabis in the county to convince the board that no, that was the wrong thing. The board apologized and is now looking into doing an EIR for a new cannabis ordinance, because a very simple thing, because there are impacts from cannabis, and there are impacts from changing the cannabis ordinance and making it easier to develop cannabis in Sonoma County. I want to say one other thing about worst case, and this also applies to SDC, I think. You may recall from the January 25th workshop that the Board of Supervisors was very interested in identifying alternatives, wanting to make sure that there was a good range of alternatives. That point was made clear, and I don't think there's any surprise there. But what they said they wanted was flexibility. And that's an interesting request to make of an EIR. I'm not sure if everybody took it the same way I did, but I think that what they're asking for is an environmental analysis that looks at worst case for all of the aspects, all of the components of the SDC plan. And I'm hoping that they'll also want that flexibility in the Springs plan, because I never heard that with respect to that, but that's just the way it goes. But the reason why you want flexibility and you want a worst case analysis is if you want to ramp up the affordable housing at high density component, or if you want to ramp up the market rate housing, or if you want to ramp up hotel space or any of those components, and you haven't looked at the impacts of that ramping up relative to the other components, you're going to go back and redoing portions of that EIR. So I'm not sure how this EIR is going to handle that, I don't even want to ask Brian to say so now, because I don't think probably he doesn't know, but if he does, I don't think it's appropriate to be saying that. But I think that's an important component of this EIR. So just because an EIR has a fairly intense level of development being proposed on any one of the components, that doesn't mean that that's a done deal. And it doesn't mean that the impacts, since the impacts haven't been identified, there's been no really opportunity to say, well, this is significant, we need to reduce it of any of those components. So in the process of evaluating an EIR and in understanding how this plays out, it's really important to look at some of these factors and make a judgment as to whether this EIR is really making a good faith effort to provide everyone, decision makers and public, with a good body of information about the impacts of a project and its alternatives. That's the real challenge in these very controversial projects that are going forward, and I'm looking forward to see how they do it. And by the way, just so you know what, sitting on the Planning Commission and recognizing that it's how important it is for the county to continue to process this SDC plan as readily as possible, given the necessity to do it right, means that we don't want to screw it up. And I'm going to do my best to make sure that the EIRs and the policy decisions are done in the right way per SQL the first time through, because this project has the potential to drag on through legal challenges and the like. And I fear that if that happens, it gives weight to the state coming in and saying, you guys are just dilly-dallying around. And while I don't think that would be the reason, I would be a little bit fearful of that would be the excuse. So it's just something that I personally am keeping in mind as I sit on this, and as I'm looking for an EIR, I'm trying my damnedest to make sure, and I think Brian O'Brien is trying to make sure that this is going to be done the right way. So how about some questions? Anybody? I yapped for 40 minutes or so. You guys, is there anything that you guys want to ask about? Joanne?
Thank you. Can you give me an example of worst case? Talk to me about what worst case means in the SQL world.
Yeah, so, okay. Let's just take an easy a market rate suburban subdivision going through on a vacant piece of property. there may be a standard number to use for traffic impacts from that type of a subdivision would be 10 trips a day per unit. Maybe these are larger units than typical. Maybe they're the type of unit that might attract more people, more trips. There are some data that show that often trips exceed that. I would argue that let's do 12. Do something like that. That's not typically done, but that's an example of how you might swing that. You'll often see, for example, a winery might have parking requirements, and there's a formula that's used for how many parking spaces per visitor, and there are projections for visitors. So are those projections common? Are they average? Are they, I always go to say, well, what's going to happen on that worst day? What's going to happen on that Saturday afternoon when you're out there and you're turning people away? This came up with the Kenwood Winery a few years ago, and the traffic analysis was using average, and people were saying, well, wait a minute, we're not worried about average. We're worried about the worst. And it's that kind of a thing. It's a judgment call oftentimes. Anybody else? Matt?
Just two questions, Greg. First of all, does an EIR have to identify the projects that are foreseeable? Meaning that, the EIRs that are going on currently for the projects that we have previously reviewed, do they identify the other ones that would have an impact on their project?
Well, I think that basically the challenge here, if I'm understanding your question correctly, is that, yeah, any project that's been applied for, I think generally speaking, Brian knows the current practice, but if you have an application in, it's going to be in the list of projects that are identified. The EIR will identify each project that is being considered as part of the cumulative analysis.
Okay. And then my second question was, you referred to the state possibly taking over the SDC leadership role as a worst case scenario, but they still have to follow CEQA rules as well, correct? I mean, so if it's an issue related to whether or not the EIR was properly properly managed, and the state said, well, we're tired of you dilly-dallying around, we're going to take it over, they still have to follow CEQA rules, correct?
They would, but they would be doing the environmental review. And that, they would, whatever project is going to be proposed there will be subject to CEQA, but it's the lead agency will change. Lead agency would be the state of California, not the county of Sonoma. And I'd be a little bit fearful of that. I'm only saying that just to be clear, that if the county appears to the state to not be pursuing this specific plan diligently, that's when the discussions will start to happen about whether or not we're really serious about doing this. And the interest of the state is that they're surplusing this property, and they want to do that. And so, but I'm not saying that if we get stuck in a lengthier EIR process that necessarily means we're dilly-dallying. I'm just saying it gives rise to the excuse if there's some interest in pursuing something other than what the county is doing. It's just out there as a potential. So.
Yeah, and I don't know if I'd characterize it as worst case. I don't think ex officio Carr did either, but
Yeah.
It does take the local planning element out of it, right?
Yeah.
So it is their standard practice with any disposition of surplus property. They have a standard disposition. Typically, this is, to many people's knowledge, the first time that they've engaged and allowed a local planning process to take place while holding off on disposition. And so I think it's partly the expediency, but it's also, I mean, it's part of the, you know, in the state legislation, right? It's the 3-year process that we've identified. You know, the state is on a parallel track. You know, they've already started talking through and, you know, preparing for an RFP, right, as part of the agreement. Having said that, you know, that shouldn't take us off, and that doesn't take me off of my track, which is, you know, how do we provide a inclusive, community engaged process? We're providing all of the information to the decision makers, everyone from general community all the way up to the board of supervisors throughout this process, right? And so we're, you know, grateful for the opportunity to get in front of the commission. I know this is a special meeting, but I do think it's, you know, the hour and a half, 2 hours, you know, however long it takes. You know, the Valley is in a unique position, right? This is quite unique, as Commissioner Carr stated. Typically, the county as a whole, yes, every 5 to 7 years they do the update. They update the housing element, you know, but that's a county-wide impact. The Springs specific plan, as well as Sonoma Developmental Center, it feels like a lot now, and it's really important policy, really important work to be had. But this is, you know, relatively new ground, and so anytime we have an opportunity to get in front of community leaders like yourselves, you know, we are looking forward to providing that information to be helpful.
Oh, can I interject just one moment here, and Commissioner Cornwall will come to you next, but there was a question in the chat that I'd like to read at the moment that comes from Andriana Duckworth. Does Permit Sonoma, the Planning Commission, or SVCAC have numbers or data to share in regards to these references of worst case scenario? I'll direct that to you, Commissioner Carr.
Yeah, I don't know. I'm not aware of any specific numbers that are set by Permit Sonoma. Brian, are you aware of that? I think it's a judgment call based on what you're seeing in the EIR. Are they looking at this in a way that you know, makes sure the impacts are fully addressed?
Well, I would say it's also quite subjective to worst case scenario to who to whom.
Would I be wrong in saying that possibly Google is somebody's good friend at this point if they wanted to do a little deeper research on an item, that they had some perspective? Because I don't hear that there's a library of these worst case scenarios. So if somebody wanted to do some personal research on a given topic, I think that's what I'm hearing, but correct me if I'm wrong.
Right.
Okay. Commissioner Cornwall.
This whole process, the community engagement and the planning, is really intensive and in-depth and expensive and time-consuming. And I'm sort of dismayed to think that we could be going through all of this, and then if we're successful, then what we're looking at is more rounds of community engagement, which is time-consuming and expensive for the actual construction of the pieces of the specific plan. And so I'm wondering, to what extent can any elements of, especially the SDC specific plan, be nailed down tight enough in the EIR to the point that when a developer of whatever kind, you know, trails, housing, nonprofit hub, anything, when someone comes and wants to actually build that piece, can they do so? And I'm not sure if I'm using this phrase exactly correctly, but by right, like that the EIR itself, the specific plan itself, makes it so that if they're proposing something that is completely consistent with what's in the specific plan, then they are just good to go and we don't have to spend months and months and who knows how many dollars reanalyzing.
Well, Brian, you could add on to this as need be, that the challenge in a good EIR for a plan is to have an EIR that works for subsequent projects. And when a subsequent project is applied for, the analysis is first in the initial study is, are the impacts of this project as now clearly defined within the scope of the environmental impact report that was approved? And the best EIRs at a program level, the answer for most of those EIRs, the answer is yes. There is even more of a yes answer for affordable housing projects. There have been some changes. I don't know all the details, maybe Brian can add to that, but there have been some changes in state law recently that exempt affordable housing projects from CEQA entirely if they are in a specific plan and there has been an EIR prepared for a specific plan. So there's some avenue there where a subsequent development project may not need even an initial study or even anything more than let's make sure it's within the scope. So that's a partial answer. In my experience, we did the airport specific plan. We've actually used a general plan program EIR in a number of situations where for the most part, the subsequent answer is their negative declaration was sufficient, or even if it wasn't exempt, because mitigation measures were available for the most part. The nice thing that a specific plan and a general plan does for you, or for things like traffic and air quality and some of the more regional impact areas, that a good analysis in the EIR will have identified some would say worst case scenario under that plan, and that the numbers that come in on the project fall below those thresholds. So that's the key. That's the value of a program EIR for a specific plan. You actually have the environmental documentation covered, and we need to hope for that. Brian, did you want to add on to that? Did I miss anything there?
No, that was great. I would just say it is, with understanding one of the top priorities at the state level is around production of affordable housing. It's evolving. I mean, there's a new state law or a set of state laws that comes through every year. So it's difficult to say, once this plan gets adopted, will there be, any new potential mechanisms, right? It's hard to just, make assumptions, right, on that. But I would say there is a, critical interest both at the local and state level to address affordable housing production and supply, and they're looking at every different avenue. But that said, I mean, this kind of goes into the topic number 6 on the outline, just on the subsequent projects. But it really is. So if you had listened to the 25th January, Supervisor Hopkins had a nice analogy relating it to an article of clothing, right? A flowy article of clothing, and that sort of gives some shape to the extent possible through the certification of a final EIR with the preferred alternative and a final specific plan that gets adopted by the board. And so any subsequent project that would come through would, if I were a project applicant, I would be looking at that. I mean, the idea is any work subsequent to the EIR, subsequent to the planning process, you're building off of that. And so to me, that gives you, pretty clear indication of what the intent of the specific plan is. And, you build your project around before it gets adopted by the board. That's not to say, we haven't seen examples in other jurisdictions where something else comes in and then they need to do a subsequent EIR, and that's to Commissioner Cornwall's point is we want to make sure that we're capturing everything, right? We want to make sure we're doing it right on this first pass. We're being conservative. We're really making sure that when there is potentially a significant impact, we're identifying that, we're acknowledging that, and we are, to the best of our ability, best within reason, we are addressing and mitigating those impacts.
A quick question here. Something you said earlier, Commissioner Carr, that kind of caught my attention was when you said the decision of what the baseline would be, and specifically talking about SDC and that specific process. It just raises the question of, when the housing element is considered within that plan, the number of individuals that had been there in the past was pretty significant, although one would argue that the baseline of the traffic patterns was different based on just the fact that those people lived there and didn't venture out much, at least that's my understanding. But how much in this EIR process and the comment period that we're looking at for people to talk on that, speak about that, is the baseline a discussion point, or is that something that has the state already considered what they believe the baseline to be? That to me is a pretty significant point, and I'm just wondering how that factors into a process like this.
Well, I'm not sure what the answer is for the projects that are going through, and I don't know what the answer is for SDC. I think that it's best for all concerned, and in line with some of what I was saying about worst case, is the baseline right now is the baseline. And there's a factor here that, Brian's consultant team on the EIR, I'm sure they're well into the EIR, so they're using a baseline which they determine and will come up for review during the hearings on the draft EIR. I do think that choosing a baseline is right for comments during the scoping period, and I personally intend to make a comment along those lines. I think that if you were to use a different baseline for SDC, if you were to say, okay, well, let's use 3 years ago, or let's use 5 years ago, or let's use 10 years ago, which do you pick? And how many people were there during that year that you picked? I think it's just from a practical matter, let alone from a policy matter, it's a difficult decision to make. And because the numbers at SDC were going down over an extended period of time, and in terms of both staff and patients. And so I guess I think sometimes we in the profession and environmental professionals worry a little bit too much about what's most obvious, and that is there's nothing going on there now, and that should be the baseline. But Brian, I appreciate it. There's a different view, and I know that on the other hand, the fact that there were activities on this parcel for many years, however different from what might come out of this plan, is important. There's an important justification for some urban type development, for some more intense development on this site, based upon the fact that it's been there in the past in some form. So I would not discount that argument as a reason to approve a plan, considering one of the of the various factors that come into play here that make feasibility and reasonableness and become a reason why you're willing to accept perhaps some more intense development than some would like. And so I think that's a good argument. I just don't think it's a good EIR argument. I think the EIR is better off being, as Brian said, being very conservative about the baseline to make sure that we know which impacts are occurring as a result of the development, And then if the fact that there were people there before becomes important in the decision-making process, those things can be weighed in. Anybody else? Why don't we go ahead? Brian's going to go through, oh yeah, Matt?
Well, I do have some questions on scoping and comments, and is Brian going to address that more specific sort of time frame as to the process itself, or should I ask those questions when he's done, or ask them now?
I think Brian's going to probably cover some of those things, but
Yeah,
let's bring him back at the end, and if he
Yeah.
hasn't answered them, we'll have another question and answer at the end, if that's okay.
it's perfect.
All right, so maybe that's a good segue then, right? We can cover topic 5 there, procedural steps and public input. And so I love the framing of just, again, appreciate the time to come here. I think it's, the fact that you've identified it as important enough to really understand the process, right? I mentioned in an earlier comment, just as the county, we don't get a whole lot of these. And so anytime we have an opportunity to walk through the process, I think a key component here that's missing tonight is just it's that there's some desktop analysis that happens from the planners, both in our offices at Permit Sonoma and more often than not, out of the comfort of our homes these days. But it's really, we lean heavily on our council, right? They our county council, they're there supporting us as our SQL experts. And so we're fortunate enough to get their support every step of this way. We have a really great team that we've pulled together for both of these projects, all 3 of the projects that we meet regularly to make sure that we are getting it right the first time. And so having said that, there's a lot of stuff that happens, sort of at the staff level, and there's really great opportunities. And what I want to use how I want to frame this next topic is really just around how public input is so critical, and how the public input, where in the process the public input really goes, right? And so at this moment we are, again, I don't want to get too much into the specific projects, but we're in the scoping period, right, of the Sonoma Developmental Center. And so that is closing on the 25th of March. And we had the scoping hearing. I consistently receive comments as a project manager, pretty much on a daily basis, which is great that we're getting such high level of engagement. And I would say my one comment here is really, when you think about the scope of the potential environmental impacts of what was presented as part of the notice of preparation, right? We identified the housing component, the non-residential component, the conversations around a new connection, a road connection. Those are all the components that is potentially the entirety of the project. And so we want to hear on comments about things that we should be looking at, right? And we've done our best to identify what we feel are the impacts that we're going to evaluate. But again, this is the opportunity for the public to weigh in. And so, similar to the question we had on the strategy of being conservative around significant impacts, I would say at this point, the public, it behooves everyone to really, have your thoughts, even if you don't feel like it's relevant or you think that it's not part of the scoping of an EIR. This is the time, and this is where, yes, it may create more work on our consulting in my side, but we want to make sure that this opportunity lends itself to hearing about the concerns from the community about the potential impacts of the project. And so once the scoping period, there's somewhat of a parallel process with the development of the specific plan itself. And so just I'll try and keep it separate just for the purpose of this presentation. But that really is that, once the scoping period closes, we've done a little bit of the initial analysis, starting to compile different levels of thresholds that we need. And then this is really an opportunity for the consultants to start preparing the draft itself. And there is a copious amount of work that goes into this. And so that's where we are very much heads down, really wanting to develop the report, really better understand the analysis and provide that analysis for decision makers, for the public to evaluate the alternatives on their environmental merits. And so the preparation happens, and I'll just point again, using the example for the Sonoma Developmental Center, we feel we can get the draft environmental impact report and the specific plan out for public review at the end of June. And so that sets off a 45-day review period with the public. Within those 45 days, there will be a hearing where we will come to the Planning Commission to receive public comment on the draft EIR. So typically we do that no sooner than 30 days after we release the draft. And so that's something that we would, that the public should expect sometime in mid to late summer. So I think in July as a date. And so we take the comments that we hear, both similar to how we did it in the scoping, right? We have the one public hearing where we receive comments, we make a presentation on the draft EIR at a high level, and we present that to Planning Commission. That becomes part of the set of public comments and responses that then our staff takes upon themselves. So at the conclusion of that 45-day window, so now this is the second 45-day window. We'll start to get to work. We'll get our heads down. We'll take a look at all the comments, and we will respond to those comments. And typically, you start to see themes, right? And so there's usually a master response. If there's a lot of questions, a lot of similar questions around the theme of protection of the wildlife corridor or fire safety, will prepare a master response to a set topic, right? And then it is part of our duty to make sure that we're being responsive and addressing the comments that are made during that period. And once what we do with those comments is we take that draft EIR, we take the comments, and then we identify a draft final environmental impact report. And so typically what happens is the draft specific plan gets released at the same time. So you're looking at the environmental report, along with the specific plan. And so there's, again, opportunity. So I would be returning to the SVCAC at that point. Prior to I think I have been working with Ariel on this. I can't remember the date, but I believe it's June that we're looking at to do just a brief presentation prior to the release of the draft. And then, ultimately before we go to Planning Commission to get their final recommendation, I will return with the draft final EIR and specific plan. And so at that point, it's, we're sort of working within the regulatory framework. We get to Planning Commission opines, we have a discussion there, we present the facts and ultimately the staff recommendation. And so a discussion happens at the commission level, and then that puts us on course, on track to get to the board ultimately to make that decision, both on certifying the environmental impact report document and adopting the specific plan. And then there's a note there I see, just a notice of completion. So there's a few steps along the way where when there is a step that we complete, similar to what we did with the notice of preparation, there's, it's more like a formality of how we're notifying the state as well as impacted agencies through that process. And I think one piece that I've seen come up a number of times just around how we're engaging inclusively with our local tribes, right? And so, our community meetings are open to the public. We want it to be inviting for all. That said, there are very specific processes and policies through state law that identify the relationship and the way that we communicate with our local tribes. And so these point to AB 52 SB 18 enacted in 2015, and that really outlines a process, right? So we go through a much more formal process, which we're currently engaged on in that process. So all of that, again, gets slotted into the draft EIR and then subsequent steps to follow that. And then we've talked a little bit about this just in the Q&A, just the subsequent projects under a specific plan. And so, I get this question fielded, asked a lot is, okay, the specific plan happens, right? So we have this process. The board has adopted a plan. The board has adopted an impact report that is the regulatory framework for any subsequent projects that come through. Does this mean that the state can sell the property and the next day a developer comes in, processes an application to permit Sonoma, and then that's sort of the end of it? And so there's much more detail to that, but I understand where I think I think we can, our head sometimes can go there. But really what the EIR does and what the plan does is we've identified a program level. And so this will identify, essentially a land use plan, an infrastructure plan, an implementation and financing plan with the specific plan. And so any project that would come in, any application that comes in 5 years from now, 2 years from now, 3 years from now, the purpose of doing the work ahead of time, ex officio Carr noted this at the top of his presentation, this provides some level of certainty, both on the private market side, but also to the community, to have some assurance that this process that we are spending our time really matters and it's impactful. And so what this does is, it does do some of the legwork, right? And so it gives you a peek into and acknowledges and puts together a mitigation plan on how to address some of those significant impacts should any subsequent plan follow and fall under the purview of this, what ultimately gets adopted, right? And so there is some quote unquote streamlining in some way, right? There, you don't do the expensive, time consuming process of another EIR. In many cases, if we do the program EIR right, if a subsequent project comes and obviously meets the objectives and the plan, that said, sometimes things change, right? It's tough for me to predict what happens 5 years from now, and so without speculating, all I can really say is it, in some ways it gives you that assurance. It gives you the I wouldn't even call it a short, well, I guess in some ways it's a shortcut, because you do, you wouldn't have to be required to do the extensive, the analysis, environmental analysis has been done, right? But staff would still continue to process the application, just like any other application that we receive at the county. All right. Well, so that concludes my portion of the presentation. Was there
I
any
just
other?
wanted to add, just adding to Brian's thing, that the Springs plan EIR is about to be scheduled for a public hearing, the draft EIR. So if you look on your list there, the DEIR hearing is pending. I don't know if there's a specific date set yet, but that's coming up soon. And the housing sites EIR that was circulated, I don't know, sometime, I think it was last year. There has been a draft EIR hearing already held, and the last we haven't heard anything since. So they're in that the stage called responses to comments, I'm assuming, and at some point that'll come back around with the draft final EIR. So that's the status of the two other EIRs that we have going in the valley, and just, you know, sort of in the outlying future, whatever the future may be, a general plan update is out there somewhere, and that is probably, when that happens, that's probably the most comprehensive EIR you'll ever see, but it is at a level of detail, county-wide level of detail. So instead of flying at 30,000 feet, you're, you know, more like flying at 50. But that's an important document to accomplish a lot of what Brian is saying. Projects that come in under that general plan are eligible to utilize that EIR as part of their approval process. There's going to be an EIR on an update of the cannabis ordinance that's going to be coming out. I think the staff and the board are just now sort of talking about what's going to be involved with that cost-wise. And there's also a specific plan update in line for the airport, county airport up north of Santa Rosa, which does have some implications, minor, but some implications for Sonoma Valley. So you are looking at a series of EIRs, and I think the sort of process that we talked about tonight, you know, gives you a little handle to the extent you might want to be involved or participate in any of those other projects. As a last thing before we do questions, I wanted to give you a couple references that I think are really good. If you want to dig further into this stuff, if you're crazy. The Governor's Office of Planning and Research, the website is opr.ca.gov. That's where you'll find the guidelines. Most practitioners don't look at the law anymore, they just look at the guidelines, although maybe Brian's right, maybe the councils are looking at the legislation, but the ones that have to do it. And there's a really good organization called the Association of Environmental Professionals that after the 70s found a lot of jobs for environmental professionals based on CEQA. And they have a really good website as well. It's CALIFAEP.org. Those are really two really good references, and through those two, you can get the actual statute, you can get the guidelines. Guidelines are periodically updated. I think there's a new 2022 out, and or coming soon, and you know, you can always ask Brian or me if you want to guess. Actually, Brian wouldn't guess. I would guess. Brian would give you a much more accurate and timely answer. And so, are there any other questions? Matt, did we get yours answered?
I think Joanne had a couple of questions. So why don't you go around and then I'll just ask mine at the end.
Okay.
I was taking notes and then I got distracted and lost my note taking. Give me the timeframes between the scoping and the DEIR hearing, and then there's another step, and I have 45 and 30 days, and then I kind of lost it. And then I don't know if any of those are there fudge factors around those dates? Do they get continued or extended for purposes, or is that possible other than going to court, or how is that accomplished?
Go ahead, Brian.
Sure. Well, we, obviously with every project, want to be, follow it by the books. I mean, we obviously have other initiatives. We feel like, so long as we are providing the space that meets, both the legal side, but also just, passes the reasonable common sense test, right? Is 45 days enough? Actually, I believe there's, like, for example, the scoping tip I've seen done in 30 days. I just, I 45 days just seems like the, sort of practice that we use, and just the ample amount of time provided to get to meet the intent of what that period is to
So
receive
these are not
comment.
statutory limits.
Which,
He's gave me
I don't-
45 days, and I was asking, is it statutory? I mean, I'll look it up, but
to give, yes. So there's a statute. Well, that's not a limit. It's, we need to provide 30 or 45 days as
Yeah,
sort
I
of
think
a minimum.
I think the statutory minimum is 30, but you really need, if you read the guidelines, you really need to make a good argument for the 30 and not do the 45. I think 45 is pretty standard practice throughout the state. I think for some projects, like some projects you just give 60. I think in this case, for the 3 EIRs that are out there, I think 45 is justified from the standpoint that one, the time frame for meeting the state deadline is important, but I think that the 45 is enough time, and that, let's face it, they're doing a full EIR, so it's not a situation where we're just going to do traffic and air quality or something, and somebody wants to make the case that geology is a impact. So I think because they're doing a full EIR, it's pretty justified to just do 45 and not go further than that.
And then your comment about fudge factor, if it's about the time between the hearing and then the closing of the scope, I mean, part of, I guess the part of the fudging could be, typically that we see is the amount of time it takes to get the draft right, ready for public review. And so that's more amorphous. Obviously we set timelines because, we're project managers and we want to communicate our information and be timely, but so, like, for example, the Springs, right? That's been around since I think it was born in 2015, and that's when my daughter was born. 6 years, going on 7 here. So yeah, there's some fudge room on that side, on that component.
Anybody else, unless Matt wants to go ahead?
Thank you. Thank you for taking the time on a Wednesday too, for, going through this pretty arcane process with
It
us.
sure is.
It's a lot of words, boy. So questions about scoping comments. If you've made public comment prior to this, you would probably want to resubmit them as scoping comments. Is that true?
Yeah, Brian, you should address that, because I think typically if you've submitted something earlier than the scoping meeting, that they'll wrap it up into the comments. But Brian, maybe you should answer that.
Yeah, I mean, we take a look at every comment that comes through for a number of different purposes. And so I would say the notice of preparation is reflective of the comments that we've seen. And to the best of our ability, we are processing prior comments. Having said that, if you have the set of comments and you want to ensure that it's part of this process, I mean, this is really the legal period that we want to accept comments on the scoping of the EIR.
Right. So all these scoping comments become part of the public record, and are they included as a summary or an appendix, or how's I mean, as a document, and you've got, I don't know, 1,000 pages of comments, how do you include those?
Sure. I mean, it's all sitting in a couple of folders on my my desktop at the moment, and so we'll make sure that we're formatting it in a way that it's part of the record. Obviously, as part of the public record,
Right.
And then, of course, as part of the EIR as well.
So, and then the same process is continued for the draft EIR as well then. I mean, public
Right.
comments, and they're all, I mean, so we're talking about potentially thousands of pages of comments alone that become part of the public record and a part of these EIRs. Is that correct?
Yes.
Okay. So
Well,
if
I
I
think
need any help
one-
sleeping
one-
other than
One distinction though, Matt, one distinction is, I think it's more or less just a smart thing for the EIR preparers to do, to have put in the appendix the comments that were submitted during scoping. I don't think that's a requirement. The responses to comments that are typically done as part of that step after the DEI hearing, make sure that if you want to make any comments on a draft EIR, that you make them during that draft EIR hearing or during the window, probably a 45-day window around that hearing. And those comments must have responses prepared to them. Whereas comments that are made during the scoping meetings don't necessarily have to have that, are not required to have a response.
okay.
What
Okay.
you'll find though is if you make comments during the scoping, and then the EIR doesn't include, for whatever reason, if you don't think the EIR addressed them, then that's a comment you make on the draft EIR. And they have to respond to, why didn't you put that in? Why did you do that kind of stuff? So that's why the most important comments are the ones that you make on the draft EIR.
Okay. All right. So what we're going through now collectively as a community to make comments, for instance, on SDC, we would be even more specific in the next cycle.
Right.
Is that correct?
Right.
Okay.
Well, you would have more information, right?
Yeah.
At that point.
Precisely, right. So we're addressing the specific things that come up in hopes that they were addressed. If you wrote a scoping comment, well, you're hoping that it was addressed, and if not, then you have to say, hey, I asked these questions and I'm really concerned about them. Brian, and then just again, the timeline on the whole, public workshops, the announcements. So there's this draft EIR period of time. It's going to end sometime, we're hoping, by the end of June. How much time in advance do you contact the public to let them know that the 45-day comment period starts, and also when the public hearings will go? I mean, is there, to Joanne's point earlier, there are probably statutory requirements for how much time you have to notice the public, correct?
Absolutely. But I mean, our practice is to go beyond that bare minimum.
Sure.
Obviously, just want to make sure that we're getting proper notification to the public. And so, we have a pretty standard process and cadence. So as projects get elevated to the level where it requires us to go to Planning Commission to conduct a hearing, there's a whole internal checklist that we go through, we process. There's the noticing, and I mean, it involves a number of staff to get that accomplished.
And just final question. So when the draft EIR comes out, that's the period of time in which the CAC again will have a hearing, and we would have comment or vote on it. Is that part of this process now? As a little, there is a resolution that's been proposed, or at least semi-proposed, and I'm just trying to understand what our responsibilities will be in relation to that document.
Yeah, and so
Go ahead, Brian.
with any of these EIRs that have an impact within Sonoma Valley, I think in practice, what we typically do is, prior to getting to Planning Commission for the vote for the actual recommendation, we would come and do a presentation. One thing that I've discussed with Ariel is an intermediate step, right, prior to the release of the draft, just because of the nature of Sonoma Developmental Center and the level of interest that I'm planning to come to provide more of just an informational high level
Okay.
context to come, but there would be no vote.
Yeah, right.
At that
Okay. Thank you. And again, thank you for tonight. Thank you very much.
Mr. Chairman, unless there's any, Caitlin's hand is up.
Commissioner Cornwall.
I'm just, I maybe you can't answer this, Greg, because I know you said you had an opinion about the baseline choice, but I'm just curious about even on what basis one would even argue for one baseline versus the other. Like what are people going to be saying who want the operating SDC as the baseline versus what are people going to be saying who want the not operating SDC as a baseline?
I think the question ultimately boils down to what's the significance of the impacts of the proposed specific plan compared to no use, and what are the impacts of the proposed specific plan compared to former full usage of the former SDC site. So the mitigation and the significance of impact will be determined by the difference between those two scenarios. The difference between 0 and the specific plan on one hand, and the difference between a fully operational SDC from the 2014-15 era versus the specific plan. I would argue that there will be a lot less significant impacts in that second scenario than there will be in the first. So that's the ultimate effect of it. But the issue really is, what is the proper baseline? What are we comparing the project to? And there's nothing going on at SDC right now. And so why would you have any other baseline? That's my personal opinion. I don't know whether the EIR preparers would agree with that or not. I think that unfortunately a different baseline means a different level of impact, different mitigation measures, and less burden on those who are seeking to reduce the impacts.
We do have one comment from the attendees that I'd like to read. Maybe a question, but it says, climate change impacts are in the news almost every day. The impacts are not entirely unknown. It appears to me that the planning process and EIRs are not yet anticipating the problems. Comment, and that was from Miss Iris Lombard.
That's a good question. Brian, you want to
Sure.
take a shot
Thank you,
at that?
Iris.
Thank you.
I mean, I would say when you think about, well, there's, I think, multi-layers to climate change. What I would urge you to take a look at is in the notice of preparation, it identifies, I believe, a number of considerations that would fall under that. So when I think about potential water impacts, so as part of the environmental impact report, there's a water supply assessment that's currently being conducted by the local water agency. And so there's data and there's information. And I would say one of the lenses that we do look at, from the board down to the project team is really the impact that our decisions have on the climate, right? This is part of the strategic plan. There's a lot of investment that the board has done around climate resiliency. And so I would say, all of our projects use that lens, and also we consider the equity of the climate change, right? So that, I think climate change impacts different communities in different ways. And so this is a good scoping comment that, Iris, if you'd like to send my way, I'll drop my email in there. Make sure that you get these questions in, and we're taking a look at it and really understanding the environmental impacts that the community wants us to evaluate in this process.
I would completely agree with Brian. I think that's a good move for you, Iris, to really find out what's going on. A lot of people don't really follow the project decision-making at the county level. We began implementing climate change policy in the general plan in 2008, before the state even adopted the new regulatory laws requiring greenhouse gas emission controls. Every discretionary project that comes before the Board of Zoning Adjustments, the Planning Commission, and the Board of Supervisors has a greenhouse gas emission component in it, basically designed to make sure that that project is doing everything that has ever been conceived of in a greenhouse gas emission reduction list. So I think there are some frustrations with greenhouse gas and climate change issues in the county that stem primarily from the lack of progress on vehicle miles traveled. Greenhouse gas emissions in Sonoma County were before 2008, were 60% vehicle travel, fossil fuel use, and 40% everything else. And we've been made gains in all of the other stuff, and we are worse in vehicle miles traveled. Maybe the fires in the pandemic might have reduced things a little bit, but that's temporary. And so until we can really bring about some change in the development patterns in this county, urban centered growth, higher levels of transit, and better pedestrian and bicycle travel, we're going to continue to suffer that problem, which is becoming a global problem, not just the United States. So I don't know, that's my speech, but I definitely feel like the county is doing just about everything they can. I think if you look it up, if you take Brian's suggestion and look into it a little bit, I hope you would come to a similar conclusion, but who knows, we'll see.
Thank you for that. Are there any other questions from any other commissioners at this point? If not, I think I'd like to, on behalf of my fellow commissioners, thank both of you for enlightening us and educating us. I really, I think
you're welcome. Now that it's over, I can say it was kind of fun.
Yeah. I'm glad to hear that. It's certainly something that we have heard about quite a bit. I know for me, it was an echo in my head without a lot attached to it. There's a lot in my head that there's not a lot attached to it. However, in this instance, it was good to get.
All I would ask you all to do is have some sympathy for Brian, because I've been in his shoes when an EIR was going through, and I at one point I actually had to rewrite one that a consultant had given us because it did a bad job, and my wife hated me for about 6 months while I was pounding the light at night trying to get a EIR that was good enough to pass muster, And it's a big management challenge, and he probably has a good team behind him. So, that'll be good. So when you want to yell at him about an EIR, which is a good thing to do when the draft EIR hearings, is yell at him, be nice.
Well, and I also ask you, Commissioner Carr, did you have a 6-year-old? You were doing it as well. So,
Well, I'll do you one better. There's a 6 and a 4 and a 5-month-old. Which you haven't heard any of them, which is pretty impressive.
Very impressive.
They're doing well.
Well, we thank you both for taking the time.
You're welcome.
And, we're better educated, and thus we're better citizens. So thank you for that.
You're welcome.
I'd like to thank my fellow commissioners for spending time as well. And I would ask at this point for somebody to make a motion. Do I see anybody's hand up? Commissioner Spalding, would you make that? You're on mute.
I'm happy to move that we adjourn, but I also want to add my extreme gratitude to our enlighteners tonight, both Guru Greg and Mr. O. Really terrific presentation. Thank you so much.
Absolutely.
So,
Do I hear a second? I have a second from Commissioner Brown. All in favor, thumbs up or say aye.
Okay.
Thank you all very much for taking time out of your busy schedules. We appreciate you all, and look forward to seeing you all on the 23rd, I believe it is. Thank you, guys.
Thank you.
Cheers.
Have a
Thank
good
you.
night.
Thanks, Brian.
Thank you.
Thank you. Be safe out there.